Frost cases that are often cited in these other cases. For those of you who are not familiar with the military and state secrets privilege, there's a good reason, and this is not to belittle its basis, but it's actually not stated in the Constitution or in any statute. That doesn't mean that it's necessarily invalid, but it is one of the most important doctrines and one of the most controversial that actually doesn't have footing in constitutional or statutory form at its creation. And with the exception of maybe the Ferris Doctrine, it is, I would say, probably the most controversial in that sense. It began, of course, with the United States versus Reynolds, which began with a crash of a plane that belonged to the Air Force, but was resulted in the deaths of 3 civilian contractors. When their families sued, the government refused to turn over critical information from the crash site. They said to a series of courts, ending in the Supreme Court itself, that report contained very sensitive national security data and information, that indeed American lives and security would be put at risk if it was disclosed. The Supreme Court fashioned out of Reynolds what we know today as the state secrets privilege. And that privilege allows the government to seek dismissal not just of cases against it, but even cases against third parties, where the government can come into a case and say, you just can't litigate this issue because we have national security interests at stake. The result is often that counsel on the other side is not given access to the information. It's basically a bullet out of the dark. What's interesting about these cases is that often lawyers, including myself, have alleged that the government was lying. In Area 51, there was a very serious question about whether the government had misrepresented to the court the sensitivity of the information involved. Area 51 was somewhat unique because I had the information. Most times, counsel does not. With Reynolds, however, the great irony is that after all these years of challenging the privilege and saying that misrepresentations are often made, that report was finally made public. And all these decades later, it turned out that the report had nothing sensitive in it. Nobody has countered that view. The report was absolutely devoid of sensitive material. What it was full of was evidence of clear negligence on the part of the government. So Reynolds was a case that gave birth to this privilege on a foundation of misrepresentation. And indeed, in the Herring case out of the Third Circuit, the circuit found that, and found that this was rather bold and raw in terms of a misrepresentation, but that they would not open up the case again, which frankly I can understand. I was hoping they would, but I don't think it was an outrageous decision. They felt that it's difficult to open up cases after that length of time. But for those of us practicing in this area, it was the ultimate irony of Reynolds, that the very thing that we complain about in these cases happened at the case that articulated the privilege. Now in Area 51, we had a case where the government declared state secrets privilege over everything and refused to acknowledge even the existence of the base. You've seen the movies. And even though we could see the base from public lands. And so we had these rather bizarre hearings where I would tell Judge Pro, Judge, if you get into a car with me, I'll point the base out to you. Okay? I can show you the base. And they didn't do that, so I finally filed a case in D.C. and waited for the Justice Department to file a venue change, which I expected. And so as soon as they put in for a venue change, I said, okay, what's in Nevada? Why am I going to Nevada? And that took about 2 weeks in front of Judge Ritchie, who actually had fun with the issue and tortured the DOJ over it. And then finally, for 2 weeks later, he said, you know what, we've had enough fun. Just go to Nevada. There's something there. Eventually, they had to admit the existence of Area 51 when we said that when we purchased Russian satellite pictures of the base and French satellite pictures, and said we were going to call the military attaché to the Russian embassy, who would tell the American people what Area 51 was. And one day later, they acknowledged the existence of the base. But they still used the privilege. And what's fascinating about Area 51 is that the thing they invoked the privilege over was a report in our possession. And so I had the report. And they insisted it contained sensitive national security information, which it did not. And a lot like Reynolds, what they did not want to admit was that there was any hazardous waste at the site. Because if they admitted even cartridges from copy machines, it would mean that they were in clear, flagrant violation of federal law. And so this all boiled down to the privilege being invoked over things like paint and questions I gave them about confirming that they have pesticides at this base, or aircraft, which we have pictures of. So that's an example of how frustrating the privilege can be. With us today are going to be panelists who are going to give you different views of the privilege. And I want to emphasize